Good morning. Welcome to day 2 of the AALS conference on rebuilding democracy and the rule of law, co-hosted by the ABA and the LSAC. For those of you who were able to join us yesterday, I hope you found the panels as rewarding as I did. The conversations about the presidency offered a wide array of perspectives and insights on this critical power in American democracy. It was particularly enlightening to have Bob Bauer and Jack Goldsmith discuss their book with us in person. And once again, I want to offer our appreciation for their work and our thanks to them for joining us. Today, we move to the topic of the franchise, that most critical tool for meaningful citizen participation in the democratic process. Our panels today will cover 3 topics: congressional legislation to protect voting rights, race and voting rights, and improving presidential elections. It's particularly fitting that we move to this topic the day after Governor Ron DeSantis of Florida signed a sweeping new piece of legislation that proponents claim will protect the integrity of elections, but which most objective observers have described as legislation that restricts voting access in ways that will disproportionately affect people of color, rural voters, and blue-collar voters. This comes on the heels of similar legislation passed in Georgia, and yesterday, legislation that passed the Texas House of Representatives that will no doubt soon become law. The legislation in Florida felt particularly personal to me. In the early 1960s, my father was a voting rights activist in South Florida, working to help Black people gain access to the franchise in a state that was at that time still very much a part of the Jim Crow South. 60 years later, much has changed in Florida, but these new attempts to make voting more difficult, wrapped in the rhetoric of election integrity, is uncomfortably familiar to my dad and to those who worked alongside him, often at great personal risks to themselves, to allow all Americans full access to their rights as citizens. It is then very fitting that today's proceedings are opened by a public servant who has become a champion of voting rights and election reform in our current era. On a personal note, it's rewarding to look back on your classmates from college, or in this case, law school, and think about those among them who have gone on to do great things in the service of others. John Sarbanes was one of those people. Someone who, even when we were in law school, had a passion for public service, social justice, and politics. Our paths have not crossed in a very long time, but I'm thrilled to reconnect with him today and to welcome him this morning to open day 2 of our conference. Congressman John Sarbanes led the US House of Representatives in passing H.R. 1, the For the People Act, a historic suite of reforms to protect and expand the right to vote, clean up corruption in Washington, and restore trust, transparency, and integrity in government. In March, when the legislation passed the House, Representative Sarbanes stated that the legislation, quote, sends a strong signal to the American people about our unwavering and longstanding commitment to enact transformational, anti-corruption, and clean election reforms. Congressman John Sarbanes has served as the representative of Maryland's 3rd Congressional District in the United States Congress since 2007. He currently serves on the House Committee on Energy and Commerce and the House Subcommittee on Environment and Climate Change. He serves as Vice Chair of the House Subcommittee on Health. Congressman Sarbanes also serves on the House Oversight and Reform Committee and its Subcommittee on Government Operations. He chairs the Democracy Reform Task Force, which has assembled H.R. 1, the For the People Act, to reform and strengthen our democracy. Born and raised in Baltimore, Congressman Sarbanes has experience working in the public, private, and nonprofit sectors. He and his family live in Towson, giving him the opportunity to drive home every night and hear from the people he serves in Congress. Listening to their concerns allows him to better represent Maryland and has shaped his work in the House of Representatives. So now let me turn the microphone over to our honored guest this morning, Representative John Sarbanes. John.
Thank you very much, Vince. It's great to be with everybody today. And yes, it has been a while since you and I have connected, so this is a great opportunity for that. Thank you for your good work. Thank you for this conference, and to all the participants and viewers and listeners for their interest in this very, very important topic of democracy reform. At what is a hugely consequential moment of opportunity, I think, for our democracy in terms of resetting the basic rules, shoring up the foundation of it. And this has been a focus of mine for some time. So it's nice to see that we've got something assembled in terms of reform that we think can meet the moment. I wanted to talk a little bit about that. You've got a terrific panel following me, including Guy Uriel Charles, who recently testified in front of the House Administration Committee on HR 1. We certainly appreciated that, and other very distinguished panelists on this topic. So I'm humbled by that, but I'll do my best to lay out a perspective here on kind of how we got to this moment of opportunity, and frankly, in some ways, crisis for the democracy. I've been paying attention to this really since I came to Congress 15 years ago, but most intensely over the last 4 or 5 years. The reality is that many Americans, arguably most Americans, have gotten increasingly disconnected from their democracy and their sense of place within it over the last 10, 15 years. And I think all of that's come to a head in the very recent past. To put it simply, they look at Washington in particular, and they increasingly have felt that Washington lawmakers are listening to a small, sort of privileged group of power brokers and not really translating the will of the broad public anymore. And that has led to deep cynicism out in the country. That cynicism has found its way to some expressions that I think have kind of rocked our democracy over the last few years, and have put a fine point on the need to provide fundamental reform, a total reset of the democracy. So we've had that angry and cynical feeling out in the public. I think in 2016, to be very honest, candidate Trump found that anger, and he sort of translated it into the slogan of coming to Washington, draining the swamp, and so forth, and channeled that in a way that he was able to take advantage of electorally. When he got to Washington, in my own estimation, he didn't do a whole lot to address that issue of draining the swamp and cleaning up our politics, but he certainly understood that the sentiment was broad and deep out in the country. And I think kind of grabbed that, took it in a destructive direction, but lifted up that it was a problem, that there was this feeling out there that needed to be addressed. The good news was that in 2018, we had a set of reform candidates that ran across the country, many of them in districts where the president had done well in 2016. They found their way to that same sentiment, that same sort of cynicism and frustration in the body politic, but they offered a different solution, one that I would argue is more restorative. And that was to say, we know you're angry at the state of our politics and our democracy. We're going to offer you the solution of going to Washington and trying to fix what's broken. And rebuild things so that you're at the center of your democracy, you feel included again. And that message was very well received. It's what allowed us to bring a reform agenda into the House of Representatives in January of 2019. And we had by that time constructed a blueprint, which ultimately became HR 1, the For the People Act, which is now S1 on the Senate side, I'm glad to see, which kind of demonstrates the priority position that this legislation has right now. But we had constructed by 2019 a broad framework bill of comprehensive democracy reform. And in that sense, we're ready to channel that frustration, anger out there in the public in a very productive and restorative direction, as I say. Let me pause and talk about what's in the bill, because it represents, in my view, a direct response to the grievances that we've heard from so many Americans for so many years. Oftentimes people look at the bill and they say, well, that's a lot to bite off. It's too big, it's too expansive. But I can tell you that in many respects, it's very lean in its response to what the public wants to see. In other words, it's meeting all of these different demands and putting them into a single interlocking package. So it breaks into about 3 or 4 or 5 key components. The first, as was mentioned, and is the central theme of much of the discussion you're having, is the right to vote and access to the ballot box. We've been hearing for years from members of the public that there's deep frustration at this crazy reality that every 2 years you have to run an obstacle course to get to the ballot box in America. We should really be the gold standard when you look around the world in terms of access to the franchise, and yet we lag far behind our peer nations. In fact, I think Freedom House recently did their democracy score, and the United States had fallen 11 points from, I think, 95 to 84, based on some of these fundamental frustrations, like not being able to vote in a convenient and simple way in this country. So many of the reforms that are included in HR 1, the For the People Act, are designed to do just that, broaden access to the ballot box. In a sense, make it so that when you get up on the morning of the day you've decided to cast your vote, whether it's filling out an oval on a mail-in ballot or going to an early voting site, or showing up on election day to cast your vote, you have confidence that you can complete that transaction without having 4 or 5 contingency plans available to you. So this is a critical component. Title I of the bill was largely written by John Lewis, who for 5 Congresses in a row had introduced something called the Voter Empowerment Act, which is broad legislation to increase opportunities for voter registration, automatic, same-day online voter registration, to expand absentee ballot voting across the country on a no-excuse basis, to establish baselines for early voting, and to push back with severe penalties on voter suppression and voter intimidation and other mischief that we've seen used to block people's access to the ballot box. So that's a fundamental component of the bill. But that's not all the public was saying to us. Yes, they want to make sure that access to voting is there, the freedom to vote is intact, but they also understand, and if you listen carefully, as I try to do with my constituents, that being able to cast your vote freely and elect people to go to Washington is only a partial answer in terms of your voice and your democracy. You have to make sure that the people that you send, when they get to the places where laws are made, in this case to Congress, to Washington, or in a sense serving in the executive branch, that they continue to carry your voice with them, and that they not be compromised by ethical conflicts, that they not be captured by big money and special interests that operate very fluidly on Capitol Hill. And so other reforms were also ones that people were clamoring for, and that we tried and have built in to the basic architecture of the For the People Act. This includes ethics reforms in terms of lobbying reforms, more transparency and accountability conflict of interest rules, a code of ethics that applies to the executive branch, reforms for how lawmakers in Congress behave, a code of ethics for the judicial branch, other things just to restore and establish in a robust way a culture of ethics in Washington. A third thing that we heard from people is high anxiety about vulnerabilities in our election infrastructure to disruption and interference from foreign actors. So we've built a whole section of the bill that addresses that component. Partisan gerrymandering has been a complaint of the public's. In a way that can be used as a form of voter suppression. So it ties directly back to the overall goal of trying to promote fair representation out there. And we have a fix for partisan gerrymandering included within the bill, because again, another key source of frustration in the public. And then the last broad area of reform, which is really fundamental, is this idea of how do you make sure that the will of the people doesn't get frustrated, compromised, or undermined by the inside influence that special interests, and particularly big money interests, can have on the way the system operates. So we have robust reforms within the bill, things like fixing the Federal Elections Commission, which doesn't operate now, it's dysfunctional, promoting disclosure and transparency of the secret dark money that's been coming into our democracy for years now, and really at a exponential level since the Citizens United case was decided back in 2010. And then finally standing up a system of funding campaigns that's based on small donors and matching funds, which is proven at the state and local level to be very empowering for everyday Americans, but also helping to promote diversity in the candidate pool, because it allows people who traditionally could not access the dollars you need to run a viable competitive campaign for Congress to be able to power their campaigns by collecting small donations and earning matching funds. And there's studies that show that this would substantially increase race and gender and socioeconomic diversity in Congress if you could get this kind of a system in place. So all of these different reforms have led to the fact that the bill is expansive. It's over 800 pages, but they're all designed to respond to the basic set of concerns that we were hearing from Americans for years. And this helps explain why when you look at the polling data, a majority of Americans of all political stripes, Democrats, Independents, and Republicans, support this kind of reform package, and it earns very high marks. Now, unfortunately, the leadership on the Republican side of the aisle in Washington has made a decision. They made it in the 116th Congress when they stood against H.R. 1, and when Leader McConnell in the Senate refused to allow it to come to the Senate floor. And they've made the decision apparently again now in the 117th Congress to stand against this and then tag it as being partisan, because there are no Republicans, at least at this moment, that are standing up to support this bill. I reject that formula for judging partisanship. My North Star on that is to look out into the country, and frankly, as a practitioner, to listen to what my constituents are saying, regardless of their political affiliation. And when you do that, you understand that this is not a partisan bill. In fact, there's nothing in this bill that's particularly controversial when you present it to members of the public. The only controversy, the only expression of frustration you get when you share the bill is, why has it taken so long for us to get to the point of actually getting this enacted into law? And that's why we have to, I think, seize the opportunity that's before us now. I do not think this is an instance in which we can do this now or do this later. I think this very much may be a case of, if we don't get this reform in place at this moment when we have the opportunity, we may not get the chance again for a long time to come. And that is why we are moving with all deliberate speed. And it's also why I'm very much saying to all comers, including to my colleagues in the House and colleagues in the Senate, that it is critical to keep the package together, not just for the benefit of its resonance out in the public, which I mentioned, but because it helps to address the different equities within, in this instance, the Democratic caucus, because I think that's the group of lawmakers that's going to have to carry this over the finish line. The different pieces of this bill, depending on what part of the country you represent, what district, what state, there's a different resonance depending on which part you want to lift up. In some places, it's the voting rights piece of the bill that's the most compelling and is the one that's getting real attention. In other places, it's the anti-corruption dimensions of the bill, the ethics reforms, the campaign finance reforms that are the leading argument to get this over the finish line. But together they create a gravitational pull, which I think is very powerful and is ultimately going to be the key to our success. Before I close here, let me just quickly acknowledge some other key pieces of legislation that HR 1 relates to. One is HR 4, the John Lewis Voting Rights Advancement Act, which would restore key parts of the Voting Rights Act of 1965 in terms of pre-clearance and establishing a coverage formula, again, that can pass muster relative to the Supreme Court. That process is underway as well. So HR 1 and HR 4 are on different tracks, in large measure because HR 4 requires an extensive record to be built in order to establish the predicate for the changes that would be proposed. So that has to move on a different timeline that's separate from HR 1, but they very much interrelate in terms of protecting access to the ballot box. And another key voting reform is HR 51, which would establish statehood for the District of Columbia. You put those three bills together, and you're talking about a robust effort to lift up the voices of Americans and make them feel confident that their voice does matter in their own democracy. Very quick on the state of play, where we are right now. HR 1 has passed the House on March 3rd and is now in the Senate. In fact, next Tuesday, the Senate Rules Committee, led by Senator Amy Klobuchar, will be marking up that bill. So that's an important milestone along the way. We very much feel and believe that getting this done in the coming weeks, not the coming months, is critical. Certainly before the August recess, to keep that momentum going. And as I'm sure some of the experts that will speak to this will emphasize, many of the key reforms in the bill, including the voting reforms that are designed to respond to this unfortunate stampede towards voter suppression that we are seeing across the country that Vince alluded to at the outset. Many of those reforms can be implemented in time for the 2022 midterms, which would be a great statement back to the American people, but only if the bill becomes law sooner rather than later. So urgency is critical here. Keeping the bill together is critical. I'll just close with this. I think last November, what we saw essentially was the American people reaching out, pulling their democracy back from the brink, fighting their way to the polls in order to do that. But on January 6th, with the attack on the Capitol, I think it became clear that what we pulled back from the brink is still very fragile, in need of a lot of care and attention and fortifying. We very much believe that HR 1, S1, the For the People Act can do that. And that's why we're pushing as hard as we possibly can to get this done. Vince, thanks very much for the opportunity. I can take a question or two if you'd like before we move to your panel.
Sure. John, thank you so much. It was really great to hear from you on this extraordinary piece of legislation. And as you mentioned, it's sweeping and it's addressing concerns that I think Americans across the political spectrum have been concerned about. Maybe one question as we wrap up. You made a really interesting point about engaging the American people around this bill and sort of trying to cut through all the noise and getting them to understand that this is a lot of common sense reform. But we also know that many of our fellow citizens are being dragged in other directions, to believe otherwise, that, allowing more people to vote is actually undermining the security of voting. So given how tightly balanced the Senate is and given how divided the country is politically, what do you think is there any one or two things you think would kind of break the logjam in kind of getting that message out so that perhaps we can convince a couple of people across the aisle on the Republican side to join with you on this?
Well, I'm going to be very honest with you. I think it's going to be difficult in this moment because the narrative, particularly around voting, is so highly charged right now. There's not a lot of middle ground there. And as I say, I think the Republican leadership, certainly on the Senate side, has made a calculation to kind of double down on the current playbook that they feel has been successful. And that's why you're seeing that resistance. All we can do, and we try to do this every single day, is to point lawmakers on the Republican side of the aisle to what the polls are telling us and should be telling them about what their own constituents feel. And yes, there are people that are quite gathered around the notion of voter fraud being kind of the dominant element of voting risks in the country these days. We don't see any evidence for that. There's nothing statistical that supports it, but people have gotten worked up around that. But I think still the broad majority of Americans favor the reforms in the voting space that we're proposing. And in fact, when I was debating the bill about a month and a half ago on the House floor, I took the time, and I didn't do it, I don't think I was doing it sort of facetiously or sarcastically. I took the time to thank Republican voters around the country who took advantage of all these various modalities of voting. I mean, Republican voters in the millions used absentee ballot voting. In fact, a lot of them used it in Florida and have been using it for many, many years. They use the early voting opportunities. Many are in states where they benefited from automatic voter registration and other things that just protect the freedom to vote in America. So those should not be controversial. And I think the average American voter out there of any political stripe understands that those things ultimately can benefit them and their democracy and lift up their voice. So we're just going to keep pointing the lawmakers back to what we think that fundamental reality is. And hopefully that may bring a couple of people behind this. If not, then yes, we are looking at potentially filibuster reform as being a prerequisite to getting this done. And that's another highly charged topic that I won't weigh into given the time constraints here. But I'll just say this. If there is the will, and I think absolutely the will to get this reform done is out there in the country. When people learn about what's in this bill, they say that's exactly what we've been calling for years. So if there is the will, there's got to be a way. And we need to find a way to get this done and get it done quickly so we can hand back to, what Americans did in November was they went out and they, like I say, in a sense, rescued the democracy, pulled it back from the brink. And now lawmakers have the responsibility to show we're up to the task as well, that we're ready to stand up and do the right thing for the democracy and form a partnership with the broad public to get these fundamental components of our democracy back to the full strength where we need them. So thank you very much for the opportunity.
Well, thank you, John, for that really wonderful opening for us. I can't think of a better way to start this day's events. Representative John Sarbanes from the state of Maryland, we're really, really pleased to have you with us today. And we look forward to seeing how the bill progresses and to working together as citizens to accomplish the goals that you've set out in this legislation. And with that, I'd like to pass it to my colleague, Erwin Chemerinsky, who is the president-elect of the AALS, to introduce our next panel.
Thank you, Vince. It's an enormous pleasure for me to be a part of this conference. I want to extend my great thanks to Judy Erwin and to Vince for all that they've done to make this such a terrific conference. Following directly from what we just heard from Representative Sarbanes' outstanding remarks, the appropriate place to start the day is by looking at congressional legislation to protect the electoral process. And we have 5 wonderful scholars to offer views on this topic. With apologies to them, I'm going to do very short introductions. It really would take most of our time if I went through all of the qualifications and publications, and we're all here to listen to them. So I'll introduce all of them very briefly, and then we'll hear from them in turn, and then there will be a few minutes left for questions at the end. The first speaker will be Guy Charles, the Edward and Ellen Schwartzman Professor of Law at the Duke University School of Law. The second speaker will be Ned Foley, the Charles W. Ebersold and Florence Whitcomb Ebersold Chair in Constitutional Law and Director of Election Law at Ohio State University, Moritz College of Law. The third speaker will be Rick Hasson, who's Chancellor's Professor of Law and Political Science at the University of California, Irvine School of Law. Rick will be followed by Lisa Marshall Manheim, the Charles I. Stone Associate Professor of Law at the University of Washington School of Law. And finally, we'll hear from Brad Smith, the Josiah H. Blackmore II and Shirley Null Professor of Law at Capital University Law School. My thanks to each of the speakers for taking time from their busy schedules, and we'll start by hearing from Guy.
Thank you, Erwin. It's a pleasure to be here. So my comments actually follow fairly directly from Representative Sarbanes' introduction. What are the reforms that Congress can implement? From my perspective, it's fairly straightforward, which is to pass for the People Act. So I will take the next few minutes to make the case for why this comprehensive omnibus federal regulation is both necessary and timely. From my perspective, I think HR 1 or S1 or for the People Act addresses what I view as 2 fundamental deficiencies of the American voting rights framework. Per our constitutional framework, voting qualifications with some explicit limitations such as race, gender, and age, and voting administration are both a creature of state law and state practice. Now, this might make sense with respect to state elections, but it makes less sense with respect to federal elections. So with respect to voter qualifications, Article 1, Section 2 provides that the House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors in the most numerous branch of the state legislature. And with respect to state practices, Article 1, Section 4 provides that the time, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But of course, Congress may at any time by law make or alter such regulations. This decentralized approach to both qualifications and practices allows the states a great deal of discretion. And sometimes decentralization is good, and sometimes discretion is useful. But for the most part, in the American context, discretion and decentralization has also served as a conduit for discrimination, racial discrimination, as well as partisan and ideological discrimination. Fundamentally, our constitutional structure does not really reflect the reality of how a modern democracy operates. And so what a statute such as HR 1 does is that it modernizes our electoral practices, and it removes the unnecessary discretion that enables the states to engage in a war of attrition. So instead of convincing voters on the basis of policy as to what the justification to vote for them, we change the electoral rules as a way of acquiring and maintaining political power. And this has to stop. So as a function of our current framework, a citizen's access to the franchise would really be more or less a function of the state's internal preferences as well as external constraints. And the Constitution imposes a limited set of external constraints, and the internal preferences for political, ideological discrimination will vary from state to state. And this is one of the reasons why we see the types of race to the bottom with respect to disenfranchisement in the states that we are currently seeing. So now enter HR 1, which from my perspective is really a voting rights act for the 21st century, which does a number of things that ought to be lauded. And here I'll focus on my time just on the voting rights portions. HR 1 modernizes our voting rules, limits state discretion, recognizes that voting is a constitutional right, and in fact, it says explicitly the right to vote is a fundamental right of citizens of the United States. It focuses on making the right accessible. A right to vote is hollow if it is not accessible. And this has been a major deficiency of the American electoral system. It has a number of really important structural features. It shifts the burden from the individual to the state. It centralizes important aspects of election administration. It standardizes voting practices. As I mentioned, it limits state discretion, and it expands the electorate. Fairly quickly on some of those features, an important move is the recognition of this bill that it is the responsibility of the state and the federal government to ensure that every eligible citizen is registered to vote. This is a significant shift from the current voting wars that we have today, where instead of fighting to undermine the right to vote, we recognize that from a normative, ideological, and cultural matter, that it is the government's responsibility to ensure that citizens have the right to vote. And additionally, there are certain sets of aspects of election administration and voting practice that ought to be centralized. That decentralization has a role, but it ought to be balanced appropriately with centralization, such as making it harder, for example, for voters to be registered in more than one state. So that way, states can't then easily disenfranchise voters when on the grounds that we think that you're registered in a fairly different state, or what the statute may do with respect to redistricting reform. It standardizes certain aspects of voting practices with respect to online voter registration, early voting, same-day registration. We know that there are certain best practices, and the question simply is, why not standardize those best practices over jurisdictions? It expands the electorate, making it easier for voters with disabilities, Native American voters, voters with Americans with previous conviction, of younger voters to access the ballot. It provides funding to states, right? So a number of really important reforms. Now, before I close, let me then address two questions. One is whether we ought to worry that this is an omnibus bill. And I think those arguments are overblown. that there are few opportunities for fundamental reform in American democracy. And once those opportunities come, we must take them, because it is the chance to really move the ball forward and to modernize our electoral practices. The second is the question of congressional power. And here I'll rely on my friend and colleague, Professor Tolson, who is the expert here. I've learned so much from reading her work, and she has more than convinced me that Congress has broad powers under the Elections Clause. She's the expert in this area to regulate times, places, and manners of congressional elections, that the Constitution is given Congress the authority under H.R. 1 to do so many of the things that the statute wants to do. So with respect to policy, with respect to ideology, with respect to congressional power, with respect to the modernization of our electoral practices, the best thing that Congress can do, and the best thing that I think we can do as citizens, is to support these types of moves that brings American electoral practices from the 19th century quickly through the 20th century, but more importantly to the 21st century. Thank you.
So I'll jump in and I'll start by sharing my screen so I can pull up my slides here. So my paper for this conference argues that Congress should pass a statute that requires candidates to receive a majority of votes in order to win a congressional election. Many Americans think that's probably already the rule, but in fact, in most states, you don't need a majority. All you need is a plurality more than any other candidate, which might not be a majority. Now, the paper explains why, in general, that shift from plurality winners to majority winners would make a tremendous difference in a wide variety of circumstances. But for today's presentation, I want to focus on one feature of the argument, which is this congressional rule would jumpstart experimentation in the states and allow states to experiment with different forms of achieving majority winners. So here's the statute that I propose. We're not going to read it all. It's short. The point here is that it actually fits on one PowerPoint slide. It's not 800 pages like H.R. 1, S1, but for a very simple change in the rule, it would achieve tremendous effects, including this catalyst for experimentation that we really need. So let's look at different electoral systems. Again, the one that's most prevalent right now is often called first past the post. We start with a partisan primary and then have this plurality winner general election. There are in existence in states some majority systems already. I'm just going to focus on a couple of them. One is what California uses, their top two system, which starts with a nonpartisan primary, mixing Democrats and Republicans and other candidates together, sometimes called a jungle primary. And the two candidates that receive the most votes in that primary move to the November general election. Another system you may be familiar with, ranked choice voting. There are different versions of it. Maine uses one version. The version that I'm going to focus on today is Alaska's system because it builds off of California. It also has a nonpartisan primary, but instead of identifying two candidates for November, it identifies four. So there are four candidates on the general election ballot, and then ranked choice ballots are used to pick a single winner from those four. The mathematical calculation that picks the winner from those four candidates is called instant runoff voting. And we're going to contrast that instant runoff voting methodology with something that Ohio State we're calling round robin voting. So again, we're going to compare Alaska's version of its top four system with instant runoff voting to this new idea we're calling round robin voting. Now, this draws on work from two Nobel laureates, Eric Maskin and Amartya Sen, but we've added a couple of features that we think are distinctive innovations that we'll explain. All right, now the reason why we're looking at these different systems is we want to tackle the problem of polarization in American politics that I think that we're all incredibly familiar with. And this slide from the Pew Research Center really illustrates this. You know, decades ago, the American electorate was essentially like the typical bell curve. Most voter preferences were towards the center of the political spectrum. But Americans literally have been pulling themselves apart, becoming more polarized towards the extremes of the political spectrum, you know, as we see here. And you know, any electoral system is going to have to take voter preferences as they come, right, and accurately translate what voters want into a winner. But what we don't want is electoral systems that exacerbate polarization, that achieve results that are even more extremist or even more polarized than what the voters themselves want. So to illustrate this, we're going to come up with some numbers. And this is designed to be a model for what might, you know, be existence in reality. We think that this is a good indication of what's going on given current polarization. So imagine a right of center state, a state that leans a little bit to the right. You know, my own state of Ohio would be an example, Missouri, Indiana, Iowa, any state like that. You know, given increased polarization, we could see a profile of the state's electorate, something like this. So about a third of the electorate is enthusiastic for Trump or a Trumpian candidate. That's where the energy is right now on the right. Likewise, the energy on the left is with the progressive movement, AOC or AOC type candidates. Sure, there's still some centrist voters. In Ohio, there's still voters who like Senator Rob Portman, or in Missouri, Senator Roy Blunt. There are just fewer of them. And you know, on the left, in a state like this, there'll be voters who want a centrist, more centrist Democrat, you know, what we thought of Joe Biden as being, in contrast to, say, Bernie Sanders or AOC. So what we now want to do is map those voter attitudes into preferences among candidates. And so, you know, starting with that group of voters, about 30%, whose first choice is a Trumpian candidate, let's just assume that their choices, their preferences are linear. So their least favorite candidate would be at the other end of the spectrum, the progressive. Likewise, on the left, the voters, the quarter of voters who most prefer a progressive candidate, moving left to right, would least prefer a Trumpian. That's a little bit more complicated in the middle. There'll be a group of voters whose first choice would be somebody, a traditional Republican like Rob Portman, but they're going to be loyal to the Republican Party, so their second choice would be a Trumpian candidate over any Democrat. And likewise, the more centrist Democrats, their first choice might be a Biden type, but they'll vote for an AOC progressive over any Republican. But there are going to be some crossover voters. We've already heard about a cohort of the electorate, sometimes called the Biden Republicans. These are voters whose first choice would be a moderate Republican like a John Kasich, but they would vote for Joe Biden over Trump or a Trumpian type. And then there'll be a slice of the electorate whose first choice would be a centrist Democrat, but they'd actually cross over and vote for somebody like Kasich instead of somebody that they perceive as too left, too socialist, or what have you. So that's our electorate in this type of state. And so now we're going to try to figure out how the different electoral systems would handle voters with these preferences. So first, let's take the typical first past the post system, which starts with a partisan primary. So we're going to ignore the left side of the spectrum and just the Republican voters in the primary. And given polarization, the Trumpian candidate is going to beat the traditional conservative in the primary and move on to the November ballot. Likewise, in the Democratic primary, the progressive is going to beat the liberal and get to the November ballot. And in the general election, the Trumpian is going to beat the progressive, most likely something like 55 to 45%, given this set of voter profiles. Now, I'm holding turnout constant between the primary and the general. You know, that's a bit artificial, but in fact, we all know that because turnout is lower and more polarized in the primary, the reality of the situation is even worse than the model that I'm presenting today. So what about the other systems? Let's start with the California top 2 system. Again, we're going to take the exact same set of voter preferences, but apply the top 2 methodology. So they look, they look at voters' first choices, right? The only thing asked in the nonpartisan primary is who's your favorite candidate. So with voters having this profile, the top 2 candidates are going to be the Trumpian and the progressive, and the liberal and the conservative are going to get knocked out. So once again, in November, the Trumpian is going to win the votes from the right, the progressive is going to win from the votes on the left, and we're going to end up with the same 55-45 result. Okay, what about Alaska's instant runoff voting system? How does that work? It's again, same set of voter profiles. Well, what instant runoff voting does is it starts by looking at those first choice preferences of the voters, and it eliminates the candidate with the smallest number of first place preferences. So that's going to knock out the liberal, and then it's going to redistribute those ballots to the other candidates. So more of them are going to get redistributed to the progressive candidate. That's going to be this group of ballots, but there's going to be some that are going to get redistributed to the conservative. So after that first distribution, this is what it looks like in instant runoff voting. Nobody's yet above 50%. So the math of instant runoff voting identifies the candidate in last place. That's now the conservative. So the conservative is going to get knocked out and with ballots redistributed. So here, again, once you knock the conservative out, the Trumpian is going to pick up the Trumpian candidate is going to pick up these 2 groups of ballots. There is going to be a slice of ballots that's going to go to the progressive candidate. But the upshot is going to be that the Trumpian beats the progressive, same result, 55 to 45%. So now let's compare this new idea that we're calling round robin voting. And we call that because it replicates or emulates round robin competition that we're familiar with from sports. Each competitor in the field has to go head to head against every other competitor to see who is the strongest in the field. And again, in sports, many examples, one from college football, the Big 12 conference, the regular season is in essence a series of round robin competition as each team plays every other team. They form standings and there's a championship game among the top 2 teams based on the round robin competition. I want you to keep that model in mind as we apply this idea to elections, but there are other examples. World Cup soccer, for example, uses a round robin tournament as the first stage of its competition. So how would this work in the context of an election? Again, we're taking the exact same state, the exact same voter preferences. Indeed, we can take the very same ballots that Alaska uses. These are the same ranked choice ballots with the same rankings of the candidates among the same group of voters, and we can create round robin competition from those ballots. How does that work? I'm going to give you a couple of illustrations. If you have 4 candidates, you're going to have 6 head-to-head matches. That's just the way the round robin math works. And so let's do the first one. Let's have head-to-head the Trumpian candidate against the conservative. Means we ignore the other 2 candidates for this matchup, and we see that among all the voters in the election, it turns out that the conservative beats the Trumpian 69 to 31%, because all of these voters on all of these ballots prefer the conservative to the Trumpian. It's only the 31% that are all in on Trump and his movement that prefer that candidate. So this is a pretty decisive 69 to 31 majority win in that head-to-head matchup. What about when it's the Trumpian versus the liberal? Again, we ignore the other two candidates for this round robin face-off, and we see that the liberal beats the Trumpian on these sets of ballots. Not as strong a victory, but it's 55%. The Trumpian here picks up the original 31 plus this cohort of voters for a 55-45 matchup. Again, we could run through all of them, not going to take the time to do that, but at the end of your round robin competition, you get standings like in football or soccer. And it turns out that the conservative candidate wins all three of the head-to-head matchups. The liberal wins 2 out of 3, the Trumpian only 1 out of 3. What's the upshot of this? If we substituted round robin math for instant runoff voting math in the Alaska system, the winner would be the conservative candidate, not the Trumpian candidate. In other words, round robin analysis identifies a different, stronger majoritarian preference than what instant runoff voting does from the exact same preferences, the exact same ballots. But I actually think there's a better use of this round robin analysis, and that's to use it in the nonpartisan primary phase of the California system. In other words, what California wants to do is to figure out who are the 2 strongest candidates in a field of candidates to put those 2 finalists on the November ballot. Well, the better way to identify the 2 strongest candidates is not do what California does and simply says who gets the most first place votes. It's instead is to construct this round robin competition where all candidates to compete against each other. And it turns out that your 2 strongest candidates are the conservative and the liberal, not the Trumpian and the progressive. So using the round robin analysis in the primary phase would in essence replicate what the Big 12 conference does in football. First round robin, then a championship general election. All right, the key insight here, I think, is that for this type of state with this type of voters given polarization, the 3 existing systems all think the 2 most polarizing candidates are the strongest, with a Trumpian candidate beating the progressive. But it's the round robin analysis that yields the insight that when all the candidates have to go head to head against each other, the 2 strongest candidates are actually the conservative and the liberal. And if those preferences hold through the general election campaign, the conservative would be the winner. So again, the paper concludes that Congress should require majority winners because in a wide range of circumstances, any majority system would be better than the plurality system. But a key point is that Congress should have this experimentation among majority systems occur in the states because it may be that states should experiment with different systems, including the possibility of using round robin voting as a way to attack and combat polarization and extremism. Thank you.
Thanks, Erwin, and thanks to AALS for convening this event. I'm very glad to be with you. I'm glad also that I've followed after Representative Sarbanes and Guy and Ned, who I think all presented kind of aspirational views as to what Congress might accomplish. I want to turn from the aspirational to realism, to what actually could potentially be accomplished by Congress in the next few months. And I think it's really important to do that because for 2 reasons. Number one, we're in a very dangerous period in American elections and democracy right now. We've come off of an unprecedented election in which a presidential candidate claimed that the election was stolen and rigged and on no basis in reality whatsoever, and convinced millions of his followers that this is a major problem in our elections. And you don't have to look any further than the fake audit of ballots that's being done right now in Arizona, and using ultraviolet light to look for strips of bamboo inside the paper of the ballots to find some supposed connection to China, to recognize what a dangerous period we're in, right? So the first reason to worry about this now is American democracy is under attack internally in a way it has never been before. And the second is that because of polarization, there's a very narrow window in which election reform can actually get through on the congressional side. It's because of Trump's hold over the Republican Party. It does not seem likely that there will be any appreciable Republican support for desperately needed election reform. And so the question then is, what can Democrats do? And of course, Democrats have very narrow majorities in both the House and the Senate. Ordinarily, legislation that doesn't go through the reconciliation process, which voter legislation would not, would require a 60-vote majority. Democrats only have 50 votes plus the tiebreaker of Vice President Harris. And so they would have to blow up the filibuster in order to pass voting legislation. And so, very small window, very good odds that Republicans take over one or both houses of Congress in the next election after 2022. So now is the moment in which election reform can happen. And so I just this morning, just before I came on, saw an article, a local article in West Virginia, in which Senator Joe Manchin was quoted. Senator Joe Manchin is someone who is not co-signed onto HR 1, who is resistant to a broad package, an 800-page bill. And so the question is, what would he agree to in any kind of compromise? And what he said this morning was that there were three principles at play: accessibility of polling places, fairness in the voting process, and a secure voting system. And it seems to me that if you were trying to strip down and pare down HR 1 into essential voting reforms, you'd have to do something like this. And if you look, for example, and we'll be hearing from Brad Smith later, at the opponents of HR 1, much of that fire is aimed, at least right now, at the campaign finance provisions of the law, the public financing provisions, the disclosure provisions, and all of that. The ethics provisions are in there. I'm a supporter of many, although not all parts of HR 1, but I think in an emergency, as we're in right now, where our very democracy is at stake, really Congress should focus on the key areas and look for some compromise that could get to 50+1 votes in order to pass that reform. And if that means jettisoning public financing for congressional campaigns, that is certainly a price that should be paid in order to get some kind of legislation through. So what would the features of a pared down election reform look like? Certainly HR 4, which is the John Lewis Voting Rights Act, preclearance provisions, restoring the preclearance provisions of the Voting Rights Act seems to be one of the very most important things that needs to be done. Congress has the power to enforce the 14th and 15th Amendments. The Supreme Court in the Shelby County versus Holder case didn't say that Section 5 itself, that the preclearance provision was unconstitutional. It instead said that preclearance was based on old data, and that was impermissible and exceeded congressional power. So new fact-finding, new data, and perhaps, as Senator Manchin suggested in the same comments that he made recently in this local discussion, is perhaps extending preclearance to all 50 states. And then there would be no complaining that one state or another has been singled out for special treatment, somehow undermining what the Supreme Court called the equal sovereignty of the states. So one measure would be aimed at preventing voter suppression. The John Lewis Voting Rights Act would do that by restoring preclearance. And I certainly think that that would be the kind of reform that used to garner bipartisan support and could perhaps get some Republican support, especially if it was not targeted at any one particular state. So one issue is dealing with voter suppression. Just last night or this morning at 4 o'clock in the morning, the Texas House passed a new set of restrictive voting laws that, among other things, criminalizes offering an absentee ballot application to someone who doesn't request one. I mean, we're really in a very sad period where just trying to make voting accessible could be a crime. And that's, I think, is terrible. Okay, so one thing is preventing voter suppression. The second is working against election subversion. I had a piece last week in the New York Times. I think this is a separate question from voter suppression. The concern here is about changing who decides what the voting rules are or how votes are counted in a way that election results could actually be messed with. One of the things that we saw Donald Trump trying to do in the aftermath of the 2020 election was trying to get either state legislatures to overturn Democratic results in the states, or try to get election officials to claim that the election was somehow fraudulent. We had the famous phone call with Brad Raffensperger, who was the Secretary of State of Georgia, to try to get him to so-called find 11,780 votes and give him a one-vote victory over Joe Biden. Since that has happened, Georgia's law that was passed that got so much attention for voter suppression actually allows for takeover of Democratic counties like Fulton County for partisan purposes. It allows for more partisanship on the election board. We're seeing all kinds of rules that would allow poll watchers to interfere with the actual counting of ballots. And so I think Congress needs to pass laws that promote this kind of election integrity, that promote this kind of secure ballot. One thing that's in HR 1 that should be passed is paper ballot requirement for every state. That is, every state's voting system should produce a piece of paper that can be recounted that provides some tangible evidence that could be used in case someone is trying to mess with election results. And the final piece, and this is the last point I'll make before turning it over to Lisa, is to deal with bolstering Republican moderates. And this fits in exactly with Ned's prior presentation. What can Congress do? Ned was talking about things like requiring something like instant runoff voting top 2 or some variation of this to try to bolster moderates. Well, one thing that's already possible and already in HR 1 is requiring states to use redistricting commissions to draw congressional districts. And that is a way that Republican moderates and Democratic moderates could be bolstered. Why is it important to bolster moderates? Because it is these moderates who are most likely to hold the line on the rule of law. And so this is a very different kind of battle than we've seen in the last, period of American history. In the 1950s, the parties were, very similar to each other. We then moved into a period of polarization, but where there was honest competition. And now we're in a stage, because of the rise of this Trumpian moment, where I think honest competition in elections is under pressure. The repeated claims that the election was stolen has provided a basis for trying to manipulate not just who in the electorate can vote, but how votes are counted. And it's the kind of moment I never thought we would see in the United States. And I was actually speaking to a reporter the other day, what would be, the standards that states should apply. And I said, go to the Carter Center, look at how the Carter Center comes up with rules for emerging democracies. And those are the rules that we're going to have to apply to our states to make sure that they are following basic principles of fairness. Things like allowing observer and press access to how votes are counted, transparency in what the rules are for counting ballots, those kinds of things, and fair access of all the candidates to understanding the machinery of the election. And so it's very sad that that's where we are now, but I think we have to put our efforts not into a kind of grandiose bill like HR 1 that doesn't have a realistic chance of getting through this Congress, but instead do triage and ask, what can we do right now to help save our American democracy? Thanks so much.
Thank you so much to Erwin and also to my colleagues on this panel and to AALS for the opportunity to join the discussion today. What I'm hoping to talk about overlaps a little bit with what Rick has been talking about, and that's because I'd like to talk about some of the challenges that face not only HR 1, which Representative Sarbanes and Guy discussed, not only a majority rules proposal like the one that Ned discussed or the many sort of sensible reforms that Rick just discussed, but the hurdles that are facing any attempt at reforming the electoral system through Congress. But I don't want to bring these challenges up for the purpose of suggesting that Congress is an inappropriate institution to turn to. To the contrary, I want to flag these problems for the purpose of suggesting that in the world of election law right now, we are facing a situation where it's not going to be enough just to turn to Congress, far from it. So what are some of the serious problems facing any attempt to reform the system through congressional statute? I would say there's at least three. First, finding a way of turning that bill into a law, just getting it through the legislative process. Second, judicial review. Any statutory reform in this area is almost certain to trigger a whole slew of constitutional challenges. And then third, ensuring that the law is actually then followed, by which I mean to say ensuring that the rule of law itself is maintained. So this first problem, getting any of these statutory reforms through the legislative process. Again, Rick touched on this and I totally agree. This is always hard to do, particularly with respect to congressional legislation. But one of the biggest problems here is that we have people in positions of power, including people in Congress, who are benefiting from the dysfunction in our electoral system. More generally, they are benefiting from sort of the anti-democratic energy generally that we've been seeing. So it's not in their interest to fix the system. They don't want to. And this sort of entrenchment, and by entrenchment here, I mean to refer to when officials try to manipulate the electoral ground rules in order to stay in power regardless of voter preferences. Entrenchment of this sort is always a problem in election law. And it's one of the reasons why it's so hard to get meaningful election law reform through, much less to get it through on a bipartisan basis. And the punchline here is that it's going to take enormous political pressure to convince Congress to act on HR 1, HR 4, a proposal like Ned's on any of these issues. So the second problem that's going to be facing any attempt at congressional reform is going to be related to constitutional challenges. So to that end, here's one data point. In March of this year, 20 state attorneys general wrote congressional leaders about this big pending election bill that we sort of keep talking about today, HR 1. In the letter sent by these state AGs, it began with constitutional objections to the bill, and it ended with a promise to sue. Now, how will these challenges fare? Not just against HR 1, but against, if HR 1 somehow passes, but against any congressional legislation? So we actually don't know, and that's because a lot of the implicated doctrines are unsettled. But if what we're talking about is meaningful structural reform to the way that states run elections, and this is reform that's enacted through congressional statute, then there are definitely going to be a range of non-frivolous constitutional challenges to bring. At a high level, for example, what enumerated power allows Congress to pass this provision, or what principle of federalism allows Congress to interfere with states' rights with respect to that provision. Surely the Supreme Court, as it's presently constituted, is going to agree with at least some of these challenges. And so as a result, even if meaningful statutory reform somehow gets through Congress, it's immediately going to head to the courts, which are going to chip away at the reform in whole or at least in part. So this gets us to the third set of concerns. So even if these laws are in the books, even if the court signs off on their constitutionality, how do we make sure that the laws are actually followed? How do we make sure that the rule of law is maintained? And this is something, of course, that as lawyers, as law professors, we so often take for granted. But particularly over the last 6 months or so, we have seen on full display the willingness of some in power to subvert the rule of law. So we've seen calls to disregard the law on entirely pretextual grounds. We've seen repeated and concerted rejection of facts and fact-based discourse. We've even seen violence, and we have seen insurrection. So it's this last set of hurdles, these threats to the rule of law itself, that in some ways is the most unsettling. And it's among the most difficult for lawyers to be able to respond to. Without the rule of law, the US Code, of course, is quite constrained in what it can accomplish. So now this is the part of an academic presentation where I'm supposed to pivot and say, in light of these challenges, we shouldn't be looking to Congress. Instead, we should be looking to some other institution or set of reforms. We should be looking to state legislatures or to the courts or to private law or norms or just to voting or whatever. But I can't do that. And the reason why is because in response to the sort of collection of overlapping pressures on election law that the country is facing right now, there is no silver bullet. Any of these other approaches are also going to implicate significant hurdles. But as the others on the panel have suggested, and I very much agree, when it comes to these issues, when it comes to maintaining the rule of law, when it comes to maintaining the electoral system that both undergirds and also depends on the rule of law, the stakes here are so high that we have to do something. We can't just sort of let this one go. Okay, so should we be turning to Congress? Yes, but that's not going to be enough. Instead, we need all hands on deck. In terms of what that looks like, this is to some extent unprecedented, but we actually do have, in a sense, a very recent precedent, and that's the precedent that was set by the 2020 elections. So out of the 2020 elections, there was not one person or one institution or one party that dragged us through what ended up being, against increasingly steep odds, a successful law-based transfer of power on January 20th. Instead, what we saw, in the words of a journalist, Molly Ball, what we saw was a vast cross-partisan campaign to protect the election, an extraordinary shadow effort dedicated not to winning the vote, but to ensuring it would be free and fair, credible, and uncorrupted. And as she goes on to explain, for more than a year, a loosely organized coalition of operatives scrambled to shore up America's institutions as they came under simultaneous attack from a remorseless pandemic and an autocratically inclined president. Though much of this activity took place on the left, it was separate from the Biden campaign, and it crossed ideological lines with crucial contributions by nonpartisan and conservative actors. So we saw these efforts. We saw these efforts before the election, we saw them during the election, and we saw them after the election. These efforts, we saw them with activist groups, we saw them with partisan actors, election officials, people in the media, academics, courts, businesses, and more. And collectively, it was this effort, this extraordinary, this exhausting, but this extraordinary effort that did ultimately work, at least for now. And this is the sort of effort that we are going to need going forward. For a host of reasons, congressional legislation is not going to be enough. And in fact, I would say no single pronged approach is going to be enough. So when we start to look at election law reform through this lens, we see that the implications are vast. To affect, support, accompany congressional reforms, we're going to need a lot of things. We're going to need at sort of a high level promotion of fact-based discourse. This might include reforms to help support independent, reliable, fact-based media and educational outlets. It also may include reforms to discourage companies and others from exploiting conspiracy theories and extremist movements to make money. We also are going to need support, a lot of support, financial and otherwise, for institutions that help to maintain the rule of law. So this includes support for election officials, support for courts, support for schools. We're also going to need brainstorming of the sort we're hearing today about democracy enhancing reforms at every level, legislative, executive, judicial, federal, state, local, public, private, and so on. Now, within this sort of world, we all have our things that we're sort of particularly focused on. For example, in my end, I'm particularly focused on right now this phenomenon that I refer to as electoral sandbagging. And the idea there is that it sort of comes out of civil litigation, where you have this practice where a trial attorney will sort of let some error occur at the trial, or even will deliberately cause the error to occur, and then on appeal, we'll point back to that error to say that there should be some sort of relief going forward. And what we're seeing in the election law space is an analogy to this, right? So we have it where basically people in charge of election systems are sort of deliberately causing problems and then pointing to those problems that they've caused for some sort of self-serving end at the back end. And so I see this and I feel like it's extremely problematic. It's corrosive to the system. It's inconsistent with democratic governance. And I would love congressional legislation to discourage this practice. That being said, my own sort of more narrow interest in this phenomenon is set against, and I think it has to be set against, a broader understanding that focusing on discrete issues alone is not going to be enough in light of the challenges facing the country. So I guess what I'll say to conclude, and then I'd love to sort of turn things over to Brad. So what we need to be thinking about is not just sort of big picture phenomenon like the electoral sandbagging that I discussed, but also simpler problems like burnout among election officials across the country. We need to be thinking about the implications of political pressures that are facing congressional leadership, like we're talking about now. We also have to be thinking about the implications of death threats that are being received by election officials in Washington state. You know, the composition of the US Supreme Court, it really matters. The composition of high school civics textbooks and curriculum also matters. It's an enormous set of overlapping tasks. This all being said, for all of the sort of bad news and problems coming out of the 2020 elections, I would again say that it does offer a glimmer of hope going forward. In response to this extraordinary set of challenges, people committed to the rule of law did come together and manage through a cooperative, cross-cutting effort to ensure a successful transfer of power. And we're going to need that same sort of vision and effort going forward.
Okay, well, thank you, Erwin, and thank you to all my fellow panelists. I get the pleasure of closing out, I guess. So I want to suggest that the dominant problem in U.S. democracy today, let's put it simply, everybody's been kind of saying it in different terms, but is the loss of faith in election results. And as my co-panelist Ned wrote recently in the Washington Post, if the losing party can't accept defeat, the whole enterprise of electoral democracy is finished. We're not talking about confidence in the responsiveness of government or the willingness of government to do the right thing. We're talking about trust in the basic accuracy of the vote count. Now, there's a widespread belief, I think, particularly amongst, frankly, people like us, right, that this is sort of a uniquely Republican problem, a party beset by QAnon conspiracy theorists and egged on by a uniquely demagogic leader in Donald Trump. And I would not dispute that that is part of the problem, but I want to suggest that it's a bigger problem than that, and it's a worse problem than that. And it is, in fact, a bipartisan problem. So to make that point, my comments for the next few minutes are going to focus almost entirely on the Democratic Party. In doing so, I'm taking it for granted, if you will, the problems that are there in the GOP and so readily apparent. Nothing here that I'm going to say should be taken as an apology for January 6th or as whataboutism. I'm not drawing equivalencies. Rather, again, I'm trying to suggest that the problem runs even deeper and won't be solved by the disappearance of Donald Trump from the scene or even by a few Republican victories in a national election. Let's start with counting electoral votes. In each of the last 3 Republican presidential victories, Democrats in Congress objected to the electoral vote count. Over a dozen House Democrats objected in 2000. In 2004, 31 House Democrats, along with Senator Barbara Boxer, objected to the electoral vote count. In 2016, Democratic objectors included my friend, Jamin Raskin, who many of you know, a former election law professor, and Representative James McGovern, who was chairman of the House Rules Committee that drafted the articles of impeachment after the January riot at the Capitol. Among those states whose electoral votes were contested were Alabama and Wyoming, states Trump won by 28 and 46 points, respectively, margins far beyond any possible fraud, suppression, or irregularities. And yet, Democrats in the House contested these, kind of sending the idea that this is a legitimate act to do by Congress if you're just unhappy with some minor element of the election. Nancy Pelosi at the time did not join the protest, but she did state, "I will support those who object." Since 2016, prominent Democrats, including Hillary Clinton, former Senate Majority Leader Harry Reid, have continued to claim, without evidence, as the saying now goes, that Russians manipulated the votes. That's an exact quote from Harry Reid. Not that there was Russian influence attempting to buy ads on Facebook, that they manipulated the votes, or Hillary Clinton stated that they hacked the computers in Florida. And these statements have no evidence in support. A poll by The Economist, or for The Economist, found that 52% of Democrats falsely believe that it is either definitely or probably true that, quote, Russia tampered with vote tallies in 2016. Note the specificity of that finding, not just Russian interference in some vague sense. A University of Chicago poll taken shortly before the 2020 election found that 62% of Democrats believe that voting systems would be used to tamper with election results. Again, that's an exact quote of what those respondents were asked. Another October 2020 poll found that 45% of Republicans believe that if the other side won, it would be at least somewhat likely due to fraud. But that same poll found that 44% of Democrats, a 1-point difference, believed the same thing, that if Democrats lost, it would be due to fraud. And while 70% of Republicans believe that mail-in ballots would be used to, quote, rig the election, nearly the same percentage of Democrats believe that the U.S. Postal Service would attempt to, quote, rig the election by refusing to return marked ballots. And in October 2020, Joe Biden himself stated that he could only lose if there was some type of vote tampering or chicanery. It's not just in presidential races. Stacey Abrams, who lost the 2018 Georgia governor's race by over 50,000 votes, continues to claim that she's the rightful winner. And far from being treated as a kook or pariah, she's a rock star in Democratic Party circles. Vice President Kamala Harris is among those who have supported Abrams' spurious claims. And for good measure, she's also added that the 2018 Florida governor's race was stolen. Since 2000, the percentage of Americans expressing confidence in the accuracy of the national vote count, as expressed in various polls, has declined precipitously from well over 50% to something typically in the range now of 20 to 30%, depending on the poll. This decline is most pronounced amongst Republicans, but note that this very large drop in Republican confidence has merely brought the parties into rough equilibrium in the percentage of their adherents who believe that they have confidence in the national vote count. Further, most of that drop in the Republican side occurred between 2000 and 2012, before the arrival of Trump on the scene. According to Pew, entering the 2020 elections, Pew polling, there's, quote, no partisan divide in confidence in the vote count across the country. Now, there's much more, but time requires me to move on. The point I want to make is simply that this problem runs deep. It exists in both parties, and it won't go away simply because Trump goes away, or even if some of the pathologies and parts of the Republican Party are resolved in at least some way, because it goes beyond the worst of those concerns. And again, it is bipartisan. Against this, what stands out to me is the irrelevance of most of the reforms being proposed in Congress. For example, one hot topic is frequently electoral college reform and constitutional amendments or national popular vote. Yet polling shows that the electoral college has been more popular over the past 20 years than it was at really any point between 1944, when Gallup first asked the question, and the late 1990s. The electoral college is actually more popular than it has been historically. Reforming the electoral college is not going to restore voter confidence in the actual counting of the results, the actual question of who won. Another pet reform, this one included in HR 1, is nonpartisan redistricting. Now, again, there's a case that can be made that indirectly this will bolster moderates and this will help and so on. But whatever the merits of the issue, it bears almost no immediate relation to this core crisis facing American democracy. And it's quite likely that it will make it worse. To the extent that the goal of nonpartisan redistricting is to create more competitive districts, recognize that one thing we do know is that voters are more likely to express confidence in the vote counts, that it is accurate, when their candidate wins. By increasing the number of close races, we're going to increase the number of voters supporting the loser in each election, and nonpartisan redistricting, therefore, will quite likely make things worse in terms of confidence in the actual vote count. Another old chestnut featuring in HR 1 is campaign finance regulation, although considerable research shows that this too has no real effect on voter perceptions or confidence, regardless of what we might think about the merits of the particular provisions in the law. In terms of election administration, the types of reforms now pending in Congress as HR 1 are based on what I believe is an incorrect diagnosis. Now, we should note the same could be said of most Republican reforms going on in the states, where the incorrect diagnosis is that there's massive fraud, which I don't think there is by any means, but this panel is focused on Congress. And the diagnosis in Congress is that there's massive disenfranchisement in the United States. In fact, I think there have never been fewer obstacles to voting in the United States. Until 1980, no state in the country had no-fault absentee voting, and almost none did until the last 20 years. There was virtually no early voting or provisional voting before 2000. All mail-in voting is a creation of the 1990s. Over the past 20 years, turnout has gone up among Asian Americans, among Hispanic voters, among African Americans. HR 1 operates on the assumption that the major reason people don't vote are legal impediments and inconvenience, and the data simply don't show that. When people are asked why they don't vote, they tend to say they don't vote because they don't care and they're not interested. As a result, whatever the merits or demerits of HR 1, it simply fails to address this loss of confidence in the actual vote count. Unfortunately, there's almost no research into what causes people to lose faith in the vote count or what can restore that faith. There have been times when Republicans have argued, for example, that voter ID laws are valuable because they'll restore at least voter confidence in the integrity of the process. That does not seem to be the case. It seems to be something that simply does not show up in the data at all. And of course, they do very little in terms of preventing actual fraud. But recognizing this lack of data, let me offer a few tentative suggestions for thinking about reform. First, although fraud is not a serious problem in American elections, until Donald Trump went overboard with his wild claims, it would have been entirely uncontroversial to note that voter fraud was more prevalent in absentee ballots than in in-person voting. Additionally, the rejection rate is higher for absentee ballots. That is, what should be valid ballots are more likely to be incorrectly excluded when they're cast as absentee ballots. And clearly, large segments of the public, mainly Republicans, perhaps due to Trump, are suspicious of extensive absentee voting. Equally important in my view is voting is a civic act that should be performed in a public setting, and it would be a good thing if voters learn that they have to have some meaningful desire to vote, enough to put up with minor inconveniences, and to think about a bit about voting. It's not the worst thing in the world to stand in line next to your neighbors for a few minutes before casting a vote that will affect those neighbors. And for purposes of credibility, it may be good for people to actually be at the polls and see the process. This goes to Rick's comment, in a sense, about transparency. At the same time, inconveniences shouldn't be unreasonably burdensome. I recognize that there's disagreement over when an inconvenience becomes a burden, but the key point is that the norm should be that voting is a public civic act. How one votes is private, but voting should be public, and voting from home should be considered an exception to the rule. Voting by absentee should not be considered the norm or particularly encouraged. And I note that Belgium, the Netherlands, France, Sweden, Norway, and many other Western democracies entirely ban absentee voting, even for cause, for people living in the country. Given this, however, two, states must assure that all areas have adequate service in polling locations, machines, and poll workers to ensure that lines do not become excessively long. If this cannot or will not be done by the state, one of the best things Congress could do would be to provide assistance through the Election Assistance Commission to funding those roles in elections. Three, reform should be simple. Suspicion in the vote count goes up when voters don't understand the process. And for that reason, I'd be very cautious about proposals such as NEDs or instant runoff voting. Although I don't really disagree with the core ideas in them, I'm not sure that that's what we want to be doing now. Four, all votes should be required to be received by the close of election day. This is an elementary anti-fraud measure. It helps prevent post-election day lead changes, which have raised suspicions of the vote count. Five, two things I agree with Rick on. So maybe here's the basis for compromise, bipartisan compromise, paper ballots, and transparency in counting. And finally, I would suggest that officials, including courts, need to restrain themselves from making changes late in the day. Sometimes it is better to let the election go forward in an imperfect fashion under rules that everybody had agreed to in advance, rather than have a court or another official step in and make changes based on some immediate crisis or need or some factor that comes up, because that's the kind of thing that opens up charges of partisanship that leaves people feeling like the rules are being gamed at all the time. I'm not sure that these proposals address the crisis either, but I think we have to restore the notion that voting is a civic act of togetherness, and we have to think of moderate reforms that aim to restore confidence in that basic idea that we can trust the count. So I'll conclude by noting the one thing I am pretty sure of. Anything Congress does do has to be the product of some type of bipartisan process, not a partisan wish list introduced with no discussion with the opposition, such as H.R. 1. In that sense, no matter what H.R. 1 contained, it would be poisoned simply because it was developed as that kind of partisan wish list on a purely partisan level. And if we want to restore confidence in the states, members of Congress, members in the state legislatures, again, this panel is about Congress, so I haven't talked about these Republican efforts in the states, but in both cases, our elected office holders have to start acting like politicians, that is, forging compromises and coming up with real solutions rather than posturing. Ultimately, the loss of faith in the vote count is the biggest issue we face and the fundamental issue to which all else is a footnote. Thank you.
My thanks to all five of you for wonderful presentations. I think I'd like to start with a question for the first two speakers and then a question for the latter three speakers. My question for both Guy and Ned is, what's possible now given the filibuster and the composition of the Senate? You've each outlined wonderful ideas for change, but I think what Rick and Lisa especially are saying is, it's just not possible. And I'd be interested in Guy and Ned for you responding.
Sure.
You want to go first?
Look, so I think there are two ways to think about this. And one way is to think about it from Brad's last comment, and then the other is from Rick's statement, which is, it is hard to think about bipartisanship if you genuinely don't have a good faith partner on the other side. I think that's just really hard, particularly if there are different ideological and partisan views on basic questions. So the basic questions such as whether voting is a privilege or whether it is a right, right? Whether people should have to make some strong effort and bear some burdens, and and people will disagree on what the burdens are, or whether the government ought to bear as much as possible, right? So where you have these fundamental disagreements about what a 21st century multiracial, multicultural, multi-democracy looks like, then the requirement of bipartisanship is, in essence, essentially saying we are not going to do anything. So where I think we are is essentially a cultural fight, a fight for sort of basic fundamental principles and rules. So even, for example, some of the suggestions that my friend Rick Hassan and my friend Brad Smith have made. So Rick's suggestion on HR 4, well, if you think HR 1 is problematic, I just can't imagine that HR 4, the return to preclearance. And so if one says, well, preclearance is going to be okay if it's nationwide, well, that just is a major federalism problem. Right? So now you're requiring all the states to subject themselves to some federal oversight, as opposed to a few of the states. It used to be the case that the court thought that what worked with the preclearance provision of the Voting Rights Act is that it limited itself only to the offending states. Right? So I think it's hard to think about when we're in a cultural moment and we're trying to think through the fundamental rules. So what matters, I think, is where we were and what can we do. This reminds me a bit of where pre-1965, where there was a lot of foment about moving us from a world of racial discrimination to a world in which we're trying to think about how to move forward. And really the grassroots organization and protest movements moved the culture. It moved Congress, it moved the court, and it enabled the creation of bipartisanship. The Democrats had to get their act together. Republicans came along, right? So I think what we need is greater grassroots participation that will move the political process and move our institutions forward. So that way we can move beyond this cultural fight over fundamental principle.
Ned?
Yeah, thanks. Here's why I think my majority winner proposal should be realistic right now, given the current composition of Congress. I think there ought to be 10 Republican senators who philosophically agree with it and see it in their own self-interest. It's essentially a federalism proposal. It's a small congressional mandate, and the mandate is simply majority rule, which is something that's sort of intrinsic in democracy. So it's not a major imposition on the states by Congress the way HR 1 should be. It's just a modest imposition of a majority rule, which people should be in agreement with. And then it allows states to do whatever they want consistent with majority rule. That's federalism. So it's a proposal built for people like Senators Blunt from Missouri or Rob Portman from Ohio. It's no accident that we've got 5 retiring Republican senators who don't want to face MAGA-motivated Trumpian primaries. And that's a real crisis given polarization. If you take those 5 senators who are retiring, they don't need to face re-election. They just need to think, what's their legacy for the good of the country? And you can have 5 other Republicans, and my 5 would be Collins, Murkowski, Sass, Romney, and Grassley. Grassley himself may end up retiring in this round. There's 10 Republicans. The Democratic Party, as President Biden said, should want a Republican Party that believes in democracy and the rule of law. So we should have the House adopt this, Democrats in the Senate should adopt this, these 10 Republicans, Biden should sign it. This should be a very reasonable proposal. Again, it fits on one PowerPoint slide.
I want to ask Rick and Lisa, is what's possible enough to make a difference? And Rick, in answering, how would you respond to Guy where he says, there's no way we're going to be able to get pre-clearance through the Senate and pass the filibuster?
Let me take that point first. I don't know about it getting through the Senate. If Joe Manchin is behind it and Democrats are willing to go along with whatever he says, it could get through. How it would fare at the Supreme Court, I think part would depend. And I saw Carolyn Shapiro's question in the chat about legislative findings. I think it's very important to make a record as to the problems. And I think, a fair Supreme Court that evaluates the question and understands Congress's power, not only under the Elections Clause, but also under its power to enforce the 14th, 15th, 19th, 24th, and 26th Amendments, has broad power. I don't know if the Supreme Court would accept that, but I think there's a strong argument to be made for that. I don't know if it is enough. I think so much of what will help save American democracy depends in part on other institutions, strengthening our institutions of free press, the role of non-governmental organizations, the law enforcement following the rule of law. A lot of the work has to be done outside of Congress, but this is a panel focused on congressional legislation. And so that's where I've put my focus, but certainly congressional legislation is not enough to save American democracy from the dangers that we're in right now.
Lisa, is what's possible enough to make a difference?
So this may seem sort of like a silly framing, but I know that there's this sort of thing that they teach people in improv classes, which is that if someone says something, then you're supposed to respond with yes and I feel like for law professors, for lawyers, that's not generally how we respond to ideas. We usually respond to ideas by saying, I see what you're saying, but at this point in sort of given what the country is facing, I think that we really should be in a yes and phase, which is to say, let's look at what Congress can do. If it doesn't work, let's just keep trying. Let's see what other institutions can do. The real question, I think, is one of prioritization. Obviously, we can't sort of spend all of our time working on all these different proposals. But again, this is a time to try to think about what might be possible and where we might be able to go rather than in a knee-jerk way, sort of rejecting things as not being possible.
Brad, I'll ask you the same question and we'll have to conclude the panel with your answer. Is what's possible with regard to electoral reform enough to make the kind of difference that you want to see?
Well, I would agree entirely with Lisa and the others that it requires more than just what Congress can do. But I do think Congress can do some things, and in response to, I would say, part of bipartisanship means you start with sort of baby steps. You start with things like paper ballots, something Rick mentioned. You start with something, I think, while again, I have some questions about whether voters would understand the round robin approach, the idea of some kind of basic statute like Ned says, I think probably could garner bipartisan support. So you need to start small rather than start large. And again, yes, it goes beyond what Congress can do, but Congress has to be part of the solution.
I have lots of questions and I'm sure we would get some through the chat, but alas, we've come to the end of this session. Again, my enormous thanks to all the speakers for terrific, thought-provoking presentations. As the moderator, my job easy. I didn't need to ask anyone to stop. You all stayed within the agreed time limit, so very grateful for that. What happens now is listed in the schedule as a lunch break. For those on the West Coast like me, I guess it could be a late breakfast or snack break. We'll resume again at 1:30 with the panel on race and voting rights. And we'll have the introduction by Kelly Testy from LSAC. Thanks again, and thanks to all watching. We'll resume again at 1:30 Eastern Time, 10:30 Pacific Time. Thanks, everyone.